County Municipal Court is reconvened.
Please be seated. All right, we are on the record in case number 25 TRD 01258, captioned the State of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Miss Yeager is here on behalf of the State of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under a OVI suspension, and the other is driving under a it looks like it says security on the citation, but according to the new Albany Municipal Code, it's basically just driving under a forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to a $1,000 fine, and up to a 1-year license suspension. Does carry mandatory minimum penalties of up to, or of at least a $250 fine, a 1-day license suspension, and at least 3 consecutive days in Licking County Jail. The other charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be 1 conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have documents, if I could serve the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been passed up from the clerk, and as well, my case is in fact on an appeal at the moment.
On appeal where?
I'm sorry.
On appeal where?
It's an appeal.
In what court? Is what I'm saying. Where have you filed an appeal?
The Court of Appeals,
Okay, which district?
the 10th District.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th District. You're absolutely right. It's the 5th District. I have
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court. That's what it looks like.
that one, or did
But just in general, all of your filings with this court are on this. It's kind of a unique.
Font.
The documents are unique in that they're gray and they're typed in all caps, and one of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division. And this is obviously Newark, Ohio.
Before we jump into today's courtroom showdown, you need to understand exactly what you're about to witness. On the surface, this looks like a fairly routine traffic case involving a suspended license and expired registration. But within minutes, it becomes something much bigger. The defendant has arrived armed with a stack of paperwork, a collection of legal theories, and complete confidence that he has uncovered a secret legal loophole capable of defeating the entire court. Jurisdiction claims other courts have some problem. The judge hearing this case has seen these arguments before. As this hearing unfolds, you'll watch a fascinating clash between courtroom reality and internet legal mythology. The defendant insists the court lacks jurisdiction, somehow taken control of the case, and repeatedly argues that the proceedings should stop immediately. Meanwhile, the judge patiently explains the law, addresses each claim, and gives the defendant every opportunity to make meaningful legal arguments. Pay close attention to what happens when the judge starts asking specific questions. Notice how often the conversation shifts away from evidence and back toward jurisdictional challenges. Also, watch how the judge balances firmness with professionalism. This isn't just a traffic case anymore, it's a real-time lesson in what happens when confidence collides with courtroom procedure. The biggest twist: some of the defendant's most important opportunities to challenge the state's case haven't even happened yet. Let's get into it.
Here's what I will tell you, Mr. Mackey. You do have the right to have a trial by jury, but in order in a what we call a petty offense, and a petty offense is anything punishable by less than 1 year in prison. A jury trial is not automatic. It has to be demanded. And Rule 23 of the Ohio Rules of Criminal Procedure require that jury demand be made not less than 10 days before the scheduled bench trial. So your request for a jury trial would be untimely. Now, I'll entertain a position from the state in that regard. Do you intend to represent yourself throughout, whether you have a bench trial or a jury trial? Or did you want the court to, or are you going to ask the court to appoint an attorney to represent you?
Represent myself, Your Honor.
Okay. Well, I'm going to go ahead and I'm going to deny what I construe to be a motion to continue for the purpose of setting the matter for a jury trial because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the motion was made, but that the court denied that. So your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to change your pleas from not guilty to guilty or no contest?
Your Honor, if it pleases the court, I motion that this case be continued and or stayed because the case is now on an appeal in the 5th District Court of Appeals. Also, the case has been petitioned removed to the Ohio District Court under case 223 CV 02962 JLG CHG and to the New Jersey District Court under case 224 CV 03934 LEFJBC. The court's jurisdiction is divested until those courts determine otherwise.
Well, actually, none of that is true.
We're only a few minutes into the hearing, and already one of the biggest themes of the entire case is emerging. The defendant is attempting to rely on filings and appeals to argue that the court should not proceed, but the judge immediately starts examining the details rather than simply accepting the claims at face value. That's something many people overlook about courtroom proceedings. Judges don't just hear arguments, they evaluate whether those arguments are legally supported. Notice how the judge asks basic but critical questions. Which court? Which district? Where was the appeal filed? Those may sound like simple procedural details, but they're often the foundation upon which legal arguments stand or fall. If the underlying facts don't line up, the argument itself becomes difficult to sustain. At this stage, the judge is signaling something important. Legal authority comes from properly filed and legally recognized actions, not merely from asserting that a higher court is involved. The defendant clearly believes these filings change the status of the case, but the court is going to require much more than belief before halting a scheduled trial.
Over you. All right.
Your Honor, I object on this bench trial. I do want a jury trial.
Okay. And as I've already explained to you, you did not make your demand in a timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me like you don't want to, I know you don't want to change your pleas from not guilty to guilty or no contest. So at this time, I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Corse to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat, but Mr. Mackey, you indicated that you do wish to represent yourself, correct? Is that right? Okay. So you have the right to be represented by an attorney by hiring one of your choosing. You're also eligible to ask the court to appoint an attorney to represent you at no cost. If you qualified based upon your income, your expenses, your household size, the court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to counsel, 1258. So I'm gonna have the bailiff hand to you a form entitled attorney waiver. I'm just gonna read it into the record in open court right now. It says, it's captioned attorney waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So if it is your intention to represent yourself and to waive your right to account to an attorney, go ahead and sign by the X there, but do please read that, because I'm going to make sure that you understand what it is.
Yes, that one.
I've been objected to this, I object this trial.
I'm sorry, I didn't hear what you said.
Refusing to sign this, Your Honor. At this moment, I'm not refusing to sign it. This court jurisdiction has been divested.